Okay, let's unpack this. We're diving deep today into a really complex legal situation that's unfolding, from just a personal legal dispute between two individuals to something with claimed broader implications.
Absolutely. It connects this specific legal dispute, as reported, to a potentially much larger societal concern about the environment for survivors speaking out.
Right.
It presents the argument, drawn straight from the legal documents quoted, that if such alleged tactics are allowed to succeed in a high-profile case like this, it could set a dangerous precedent.
A precedent that harms not only individuals in these big cases, but potentially anyone who considers coming forward, making it harder and costlier for them to do so, potentially chilling speech across the board.
So the source is essentially reporting that Lively's site is arguing that this countersuit isn't just about Blake Lively and Justin Baldoni. It's allegedly about a pattern of behavior that, if unchecked, has wider damaging effects on the ability of survivors to speak openly and pursue justice through legal channels.
Yes, it transforms the narrative, as presented by Lively's site and the source, from a personal conflict into one with significant potential implications for the post-#MeToo legal landscape. And the source highlighting that these documents specifically mention the impact on survivors from all socioeconomic backgrounds, from those with the least means to high-powered celebrities.
Right. That reinforces the point that, as framed by Lively's side, the principles at stake allegedly extend far beyond this particular case. It's about the accessibility and safety of speaking out for everyone, which they claim is threatened by tactics like DARVO.
This is really complex, and it brings us to another fascinating layer. The source reveals the involvement of external voices and organizations. It reports that this dispute isn't confined just to the parties involved and their legal teams.
No, it's drawn in significant external support, specifically for Lively's position, according to the article.
Yeah, the source highlights this external involvement, reporting that 19 leading survivors and organizations are speaking out.
19? That's quite a coalition.
It is. Speaking out specifically against Justin Baldoni's legal actions in this case, that's a significant number, isn't it? It shows the level of concern this case, as reported, has generated beyond the immediate parties.
Definitely. And the source specifies what these groups are devoted to. It says women's rights, children's rights, and domestic violence.
So these are organizations with deep experience and focus on vulnerable populations and issues of abuse and harassment, not just random groups.
Exactly. Established organizations in those fields. And the mechanism of their involvement, as reported by the source, is through the legal system itself.
How are they getting involved legally?
They have signed on to 4 separate amicus briefs.
Okay, let's quickly clarify that for anyone listening.
Yeah.
An amicus brief, it's Latin, means friend of the court.
Right.
It's a legal document filed by someone who isn't a party directly involved in the case, like Lively or Baldoni, but who has a strong interest in the outcome.
Or expertise relevant to the issues.
Right. They submit information, expertise, or arguments that they believe are relevant to the judge's decision. It's a way for external parties to provide input to the court on a case that they think has broader implications beyond just the people suing each other.
Precisely. And the source quotes Lively's spokesperson regarding the unified position of these 19 organizations. The spokesperson states they are united in opposing Justin Baldoni's attempt to dismantle a law designed to protect women who speak up simply to protect himself.
Wow, okay, that's a powerful claim reported by the source that Baldoni's actions are allegedly aimed at dismantling a protective law.
It's strong language.
It is. Now, the article doesn't explicitly name the specific law these organizations are concerned about him challenging, does it?
No, the source doesn't specify which law, but it reports their position, via Lively's spokesperson, as opposing his attempt to undermine a law intended to protect women who speak out.
So this suggests the legal battle involves challenges to establish legal protections, according to these organizations, and as reported by Lively's spokesperson.
That seems to be the core of their concern as presented. And the source does list some specific organizations mentioned as having signed on to these briefs.
Who are they?
Child USA, Sanctuary for Families, the National Organization for Women and Now W.
Okay, very well known.
Women's Justice, NW, and the National Network to End Domestic Violence.
These are indeed well-known and respected names in the fields of advocating for survivors and vulnerable populations. Having them weigh in is significant.
The source characterizes these voices as adding to renowned nonprofits, victim advocates, and experts from around the world. It describes them collectively as being dedicated to safeguarding the rights and well-being of people who speak up.
And what's the message they're sending, according to Lively's spokesperson, as reported in the source?
The spokesperson is quoted saying these groups are sounding the alarm.
Sounding the alarm. But what specifically?
About Baldoni's alleged DARVO tactics and their potential chilling effect on other survivors considering coming forward. It echoes the concerns raised in Lively's own reported legal documents.
Let's really dive into the significance of this. Having 19, numerous well-regarded organizations focused on women's and children's rights and domestic violence, sealing legal briefs to the court in a case like this. What does that add to the picture presented in the article? Especially their stated concern about protecting laws and the potential chilling effect.
I think this is where the case, as presented in the source, clearly moves beyond just a private dispute between two famous people. The involvement of 19 external organizations actually filing legal documents with the court.
Yeah.
It signals that these experienced advocates and legal experts see something in this particular case, specifically in Baldoni's legal response. It seems that they believe has significant implications for the broader legal and social landscape for survivors.
It tells us that, from their perspective, as reported, this isn't just about the facts of the initial accusation or even the merits of the $400 million defamation claim. It's about the strategy they perceive Baldoni's side is employing, and what that strategy could mean for the ability of anyone, particularly women, and those affected by sexual violence or domestic abuse, to safely and effectively speak out and seek legal recourse in the future.
Exactly. The source highlighting their concern about opposing an alleged attempt to dismantle a law designed to protect women who speak up indicates that these organizations believe fundamental legal protections are potentially being challenged through Baldoni's legal actions in this case.
So their amicus briefs are a way of bringing their expertise and advocacy directly into the courtroom.
Yes, to argue against what they see as harmful legal tactics or interpretations of law that could weaken protections for people who speak out.
And the phrase sounding the alarm about the chilling effect, quoted from Lively's spokesperson, that really reinforces the connection, doesn't it, between the alleged tactics in this specific case and the potential broader impact on that culture of silence we talked about earlier.
It does. The source uses the involvement of these respected groups to lend weight to the argument presented by Lively's side that this case could have significant consequences beyond its immediate resolution for Baldoni and Lively.
It elevates the stakes considerably. These organizations are, in effect, telling the court, and by extension the public via this reporting, that the court's decision here could influence whether other survivors feel it is safe or even feasible to come forward in the future.
And whether legal frameworks designed to protect them remain robust and effective. The source naming specific reputable organizations adds a layer of credibility to this concern, as it's presented in the article.
It certainly paints a picture, based on the source, where the legal battle isn't just about winning or losing on the specific claims between Lively and Baldoni, but about the potential impact on the legal environment for survivors overall.
And the source highlights this by presenting the organization's involvement as directly tied to opposing Baldoni's specific legal moves and voicing concern about their potential chilling effect. It's a key part of the narrative reported.
Now, the source introduces another sharp point of contention. This one focuses on what Lively's side alleges is a stark contradiction.
Ah, yes, the public persona aspect.
Exactly. A contradiction between Baldoni's public persona and his reported actions in this current legal dispute.
Yes, the source presents a specific accusation directly from Lively's spokesperson. They are quoted saying that Baldoni is contradicting years of his own public persona.
Contradicting years of his persona. And the source explains the alleged nature of this contradiction.
It does. It's about him allegedly abandoning the message he reportedly promoted in his past, #MeToo related content.
What kind of content?
Things like YouTube videos, podcasts, TED Talks, interviews, work that was part of his public profile where he apparently addressed these kinds of issues.
Okay, and the source then provides a direct and frankly powerful quote of the message Baldoni allegedly promoted in that past public work.
It's quite specific. The quote provided in the source is that he, once upon a time, urged men to listen to the women in your life, to hold their anguish and actually believe them, even if what they're saying is against you.
Listen, hold their anguish. Actually believe them, even if what they're saying is against you. That's a really specific and impactful quote reported here.
It is. And the source uses it to draw a very clear contrast.
A contrast between what?
Between that stated past message, which emphasized listening to and believing women, even when their accounts are difficult or accusatory, and the current alleged actions he is taking now that he is the one being accused.
Actions like filing the massive countersuit, challenging these organizations, allegedly using DARVO tactics, all the things we've discussed based on the reporting.
Exactly. The source is framing the section around the perceived inconsistency, as alleged by Lively's side, between Baldoni's past public advocacy related to the #MeToo movement and the legal strategy his side is reportedly employing in this case.
So it's highlighting the tension between his stated public principles and his alleged actions in response to the accusation against him, specifically from the perspective of Lively's spokesperson.
That's the focus of this part of the source's reporting.
Let's discuss the specific contrast the source draws using Baldoni's alleged past words versus his current actions. How does the source use this comparison to frame the current situation? It feels like a deliberate point being made.
Oh, absolutely. The source, by prominently featuring that quote about listening to and believing women, is presenting an argument, as made by Lively's spokesperson, that Baldoni's current legal approach directly contradicts his own previously articulated values.
Right.
It's using his past public persona, reportedly built partly on advocating for listening to women's stories, to question the legitimacy or perhaps the consistency of his current legal defense.
A defense which involves, as alleged by Lively's side and reported by the source, filing a huge defamation suit and employing tactics they label as DARVO.
Exactly. So it's not just a legal claim being reported here. It's a strategic narrative being built by Lively's side and reported by the source, suggesting that Baldoni's actions are hypocritical given his public history on these issues.
It positions the legal battle as one where Baldoni's own passwords are being used to critique his present behavior. It's quite a targeted argument.
Precisely. The source presents this contrast to suggest, based on Lively's spokesperson's statement, that Baldoni's current legal strategy isn't aligned with the principles he reportedly championed publicly.
It adds a dimension of alleged ethical conflict to the legal dispute, doesn't it? Framing it in terms of consistency and authenticity related to his past #MeToo advocacy.
It does. And the power of this point, as reported, lies in the directness of that quote attributed to him and the stark contrast drawn by Lively's side between that statement and his current reported actions.
It implies, through this specific reporting, that Baldoni's opponents see his actions not just as a legal defense, but as a kind of betrayal of the message he himself promoted, particularly that challenging idea that men should believe women even when it's against them.
Right. It's using his own reported platform against him in the public framing of the case, as reported by the source via his spokesperson.
And the source highlights this point directly, quoting the spokesperson, indicating this is a key element of how Lively's side is articulating their position and challenging Baldoni's defense strategy outside of the courtroom through public statements reported in the press.
It's definitely part of the public relations battle surrounding the legal case.
Okay, shifting focus back to the courtroom itself, the source provides details on some specific skirmishes happening within the legal process, describing it like a legal chess match.
Yes, the source reports on a particular back and forth regarding Lively's claims for emotional distress damages.
Emotional distress. Okay, what was the issue there?
It notes that earlier in the month, Baldoni's legal team had apparently claimed that Lively was seeking to remove these specific claims from her lawsuit.
They claimed she wanted to drop the emotional distress part.
That's what Baldoni's team claimed, according to the source, and the source provides crucial context for this claim.
Yes.
It reports that this assertion from Baldoni's side came after his team had sought Lively's medical records during the discovery phase of the lawsuit.
Ah, okay. So discovery is the pretrial phase where parties gather evidence from each other, right? Like documents, depositions.
Exactly. And seeking medical records in a case involving emotional distress claims is a fairly standard legal tactic. It's how the opposing side might try to verify or, challenge the claimed extent of emotional harm.
So the source reports Baldoni's team sought these records, and then they claimed Lively was looking to drop the related claims. That timing seems relevant.
The source presents it sequentially, yes. It even notes that Judge Lewis Liman, who is presiding over the case, mentioned Lively's reported representation, meaning what her legal team had reportedly indicated about dropping claims in a letter obtained by Variety.
So there was some official communication or maybe a misunderstanding about her intentions on this point.
It suggests something was communicated to the court, yeah. But the source immediately follows this with Lively's counterposition, as stated by her representatives.
And what was her side saying?
She, for her part, stated unequivocally, according to the source, that she had no plans to drop the claims of emotional distress.
Okay, so a clear conflict in the reports about her intentions. One side saying she's dropping them, her side saying absolutely not.
Exactly. It seems there was some confusion or disagreement there.
And how did the judge resolve this specific issue?
The source reports the judge's ruling on this specific issue came on Tuesday, June 3rd, and the ruling stated that the issue was officially dead.
Officially dead? What does that mean?
It indicates that the point of contention over whether Lively would drop her emotional distress claims had been definitively resolved by the court. And it seems to align with Lively's stated position that she would not drop them, based on the source's reporting of the outcome. That specific argument was over.
Okay, so that particular skirmish seems resolved in Lively's favor, based on the report.
It appears so, yes. The source then details further legal maneuvering based on statements from Lively's lawyers made after this specific ruling.
What else happened?
They reportedly stated that the court had denied a motion from Wayfair.
Wayfair, that's Baldoni's company, right? Also a party in the suit.
Yes, exactly. The source specifies that Wayfair's motion was denied by the court. It doesn't detail what the motion was about, just that it was denied.
Okay. And Lively's lawyers reportedly clarify the current status regarding other claims in the lawsuit.
They did. They stated the judge told the parties to discuss technicalities of how 2 of the 15 claims will be voluntarily dismissed.
Okay, wait. So out of potentially 15 total claims in Lively's initial lawsuit, 2 are being discussed for voluntary dismissal by her.
That's what her lawyers stated, according to the source. 2 out of 15.
Why would she offer to dismiss them? Is she backing down?
Well, according to Lively's lawyers, she is offering to dismiss these specific 2 claims, not because she's retreating on the overall case or the emotional distress aspect,
Okay.
but because they are no longer necessary.
No longer necessary. What does that imply?
As reported by her team, it implies perhaps a consolidation or refinement of her legal arguments. Maybe those 2 claims were redundant or less critical to her main case, so they're streamlining things. It's framed as a strategic adjustment, not a retreat.
And crucially, the source quotes Lively's lawyers reiterating that despite potentially dismissing those 2 specific claims.
Yes.
She will continue to pursue emotional distress damages through other claims that remain in her lawsuit.
Right. They specifically mention pursuing those damages through the core sexual harassment and retaliation claims, which are presumably still active. So the pursuit of emotional damages linked to the main allegations is reportedly still very much on the table.
Okay, that's an important clarification from her side, reported in the source.
And the source also includes a very pointed accusation from Lively's lawyers regarding that denied motion from Baldoni Wayfair we just mentioned.
What do they say about it?
They are quoted as calling it an utterly pointless motion to compel, all searching for yet another press moment.
Wow. Utterly pointless, and just for a press moment. That's strong language to be reported from a legal team about an opposing motion.
It is. It reveals the level of animosity and, the strategic interpretation happening outside the direct court arguments. They're accusing the other side of playing games for the media.
It shows the public narrative battle is deeply intertwined with the legal maneuvers, as presented in the source. It suggests Lively's lawyers believe that specific motion wasn't a serious legal effort, but an attempt to generate headlines or frame the situation publicly in Baldoni's favor.
That seems to be their reported take on it. And finally, the source reports a claim by Lively's lawyers about the potential consequences of Baldoni Wayfair's larger countersuit strategy, the $400 million one.
No consequences.
They state, according to the source, that filing these retaliatory claims has actually exposed them, Baldoni and Wayfair, to expansive damages under California law.
Expose them to damages. How does that work?
Well, let's really dive into these specific legal skirmishes reported in the source, the back and forth over emotional distress claims and medical records, the denied motion, the voluntary dismissal of other claims. What does this level of detail reveal about the strategies being employed, as reported?
Yeah, and what are the alleged stakes and potential consequences of these specific legal maneuvers, according to the source? Particularly that last point about them being exposed to damages.
Okay, so what's fascinating is how the source breaks down these granular legal steps. It shows the active, tactical fighting happening within the court process. It's not just waiting for a trial.
It's constant maneuvering.
Exactly. The dispute over emotional distress claims and Baldoni's team seeking medical records that's somewhat standard for validating such claims, as we said. But the conflicting reports about whether Lively intended to drop them suggest either a breakdown in communication or perhaps, as Lively's side might see it, a strategic misrepresentation by Baldoni's team that the judge ultimately had to clarify.
And the judge ruling that issue officially dead, as reported, implies that a specific point of contention is resolved, right?
Mm-hmm.
It allows the case to move forward without that particular ambiguity hanging over it.
Yes, it clears the air on that specific procedural dispute. Then you have Lively's side voluntarily dismissing 2 claims out of 15.
Which they frame as just cleaning up.
Right. While they call them technicalities and no longer necessary, and insist they are still pursuing emotional distress damages through other claims like sexual harassment and retaliation, it still shows an adjustment in their legal strategy.
Refinement, maybe.
Perhaps consolidating their arguments or dropping points they feel are weaker or maybe duplicative, as suggested by the no longer necessary explanation from her lawyers, as reported. It's a strategic move within the larger case.
And the accusation that Baldoni's motion was pointless and just for the press, that's the legal teams using the media via this reporting, to frame the opposing side's actions in a really negative light.
Absolutely. It shows the public narrative battle is happening alongside the legal maneuvers. It suggests Lively's lawyers believe that specific motion wasn't a serious legal effort, but primarily an attempt to generate headlines or shape public perception.
Okay, now about that final point, the claim by Lively's lawyers that Baldoni and Wayfair's strategy of filing the large retaliatory claims lawsuit have actually exposed them to expansive damages under California law. That sounds potentially huge.
It's a significant assertion reported in the source. It suggests that California law might have specific provisions that penalize lawsuits deemed to be purely retaliatory, especially in contexts like this.
So laws against suing someone just because they sued you first, essentially, or for speaking out.
Potentially, yes, or laws that allow for extra damages if a lawsuit is found to be malicious or retaliatory. And Lively's legal team, according to the source, believes Baldoni's action falls under these provisions,
which could put him and Wayfair at risk of significant financial liability back towards Lively.
That's the implication of their reported statement. So, based on the source's reporting of Lively's legal team's statements, the alleged stakes of filing the countersuit aren't just about winning or losing that $400 million claim.
Right.
They potentially include opening the door for Lively to seek substantial financial damages from Baldoni, specifically because of the alleged nature and intent of his countersuit.
So they're framing it as a potentially legally punishable act of retaliation under California law.
That appears to be the argument reported from her lawyers.
That portrays Baldoni's $400 claim as a kind of double-edged sword that could potentially cut back against him, as argued by Lively's lawyers in the source.
It certainly highlights how, according to the statements reported in the source, every single legal move is being scrutinized, labeled, and framed within this larger narrative of alleged tactics and potential legal exposure on both sides.
It's a complex, high-stakes legal and public relations dance playing out simultaneously.
It really seems to be, based on this reporting.
Which brings us to the final outlook presented in the source, discussing the path ahead and the broader implications of this ongoing dispute.
Right. The source reiterates that this legal battle is Clearly far from over, it is very much an ongoing legal process.
And no quick resolution in sight.
Doesn't seem like it. And it states the key future milestone mentioned in the article. The case is currently set to go to trial in 2026.
2026, wow. That reported date tells us this is expected to be a lengthy and really drawn-out legal process spanning years from when it started.
A trial date that far out suggests a significant period ahead for discovery, gathering more evidence, likely further motions being filed and argued, and then all the preparations for potentially presenting the case to a jury or judge.
It implies the intensity and the legal investment required from all sides will continue for a considerable time. This isn't fading away soon.
No, it seems deeply entrenched. And the article, in summarizing the situation, allows us to synthesize all these intertwined elements we've discussed, all drawn directly from this one source.
Right. Let's recap those elements as presented.
Okay, you have the initial serious sexual harassment accusation by Blake Lively.
Check.
Justin Baldoni's immediate denial, and then the filing of that massive $400 million defamation countersuit that also targeted Ryan Reynolds and Leslie Slum.
Yep, the huge escalation.
The detailed legal sparring happening in the courtroom over things like emotional distress claims, medical records, those specific motions.
The legal chess match.
Right. Then the specific allegations made by Lively's side about legal tactics like DARVO, drawn reportedly from her legal documents.
The framing of the countersuit itself.
The involvement of numerous well-known advocacy organizations submitting those amicus briefs to the court.
The external alarm bells.
And the public statements being made by legal teams framing the actions of the other side, like calling motions pointless or warning about exposure to damages. All of this woven together as presented in this SEBI source.
And connecting this back to you, the listener, the source, through the reporting of Lively's legal documents and the statements from those advocacy groups, it points repeatedly to that potential chilling effect on survivors.
Yes, and the impact on people across all socioeconomic backgrounds if the tactics alleged in this case were to succeed. It frames the stakes broadly.
The article, through the quotes from legal documents and spokespeople, frames this case, as reported, as a kind of microcosm, an example of the complex challenges that can arise when serious allegations intersect with these high-stakes legal battles, huge financial claims, and very, very public narratives.
It demonstrates how, based on the source material, an initial accusation can escalate into this multifaceted legal conflict. It involves not just the core claims, but substantial financial counterclaims, detailed allegations of harmful legal tactics like DARVO, and even the involvement of external organizations worried about the wider societal implications.
Implications for the safety and ability of people who speak up about sensitive issues.
That's the concern highlighted in the reporting.
Let's take a moment to really think about what the reported timeline, that 2026 trial date, suggests about the expected duration and intensity of this legal process. It's just a long way off.
It really is. That 2026 trial date is a stark indicator. It suggests this isn't a case headed for a quick settlement or an early dismissal, at least not at the time of this article's reporting. These kinds of drawn-out timelines are often characteristic of really complex litigation, where the facts are hotly contested, significant discovery evidence gathering is needed, and numerous motions are filed and argued back and forth.
It implies both sides are digging in for the long haul.
It suggests they're prepared for a prolonged and likely very costly legal fight requiring substantial resources over several years. The intensity isn't just in the headlines or the dollar figures, it's embedded in the expected length and complexity of the legal process itself.
And then how do these different threads of the story presented in the source, the core accusation, the enormous reported countersuit value, $400, the explicit allegations about sophisticated legal tactics like DARVO backed by quotes from legal filings, the chorus of concerned advocacy organizations formally weighing in via amicus briefs, and the reporting of specific court skirmishes over things like evidence, how do they weave together? It's not just a list of events, is it?
No, the source doesn't just report facts sequentially. It creates a picture, drawn solely from this article, of a legal battle being fought simultaneously on multiple fronts.
Multiple fronts. Like what?
Well, obviously on the facts of the initial claim, did the alleged harassment occur or not? But also on the legality and the intent behind the countersuit. Was it a legitimate defensive reputation, or was it, as alleged, retaliatory defamation?
Okay, facts and intent.
Then there's the battle over the nature and the alleged harmfulness of the legal strategies being used, the whole DARVO framework discussion.
Right, defining the tactics themselves.
And finally, it seems there's a battle in the court of public and advocacy opinion, influenced by things like the spokesperson statements and those amicus briefs filed by the organizations.
So it highlights how, according to the source's reporting, the narrative around the case, how it's framed, what tactics are alleged, who is portrayed as the victim or the aggressor, is as much a part of the battle as the direct legal arguments presented in court.
Absolutely. The source reports Lively's side is actively framing the countersuit as retaliatory and an example of DARVO, and it reports the advocacy groups are sounding the alarm about the chilling effect. This suggests a deliberate effort, as reported, to define the terms of the conflict and its potential wider impact beyond just the two main parties.
This implies, based on the picture presented in the source, that a key component of this high-stakes legal dispute is the strategic effort by the parties to control the public understanding and the legal classification of the actions being taken.
It seems that way. It's not solely about proving or disproving the initial accusation or the defamation claim. It's also reportedly about convincing the court and perhaps the public about the true nature of the legal battle itself.
Is it a legitimate defense or an abusive tactic? And what are the potential consequences of letting such tactics, if they are indeed being used as alleged, succeed? That seems to be a central question raised by the reporting.
And the potential significance implied by the source extends beyond the individuals involved, precisely because of that report involvement of the 19 advocacy groups and the prominent discussion of the alleged DARVO tactics and the chilling effect.
Right, those elements broaden the scope.
The source presents the argument, as made by Lively's side and those supporting organizations through their amicus briefs, that the outcome of this specific case, and particularly how the court views and addresses the alleged tactics, could have repercussions.
Repercussions for what?
For how similar cases are handled in the future, and perhaps more importantly, whether individuals feel empowered or deterred from speaking out about their experiences, knowing they might face similar high-stakes counter-litigation.
So the source effectively positions this, based on its reporting, not just as a celebrity legal dispute, which obviously garners public attention.
Right. Those always get clicks.
But as one with potential ramifications for the broader conversation around accountability, legal strategy in response to allegations, and the legal landscape for survivors, particularly in the post-#MeToo era.
That seems to be the implication woven through the source's narrative. And the fact that the legal fight is expected to last until at least 2026 underscores the deep commitment by all sides to pursuing their claims and defenses and the potential endurance of the complex issues raised by this case.
It certainly makes it clear this is a multifaceted and deeply contested legal battle, based on the details provided in this source. The weaving together of personal accusations, huge financial claims, alleged specific legal tactics, external advocacy, and courtroom maneuvers paints a very, very complex picture.
It truly does.
And that brings us to the end of this deep dive, drawing specifically and solely from that single source we examined today about the ongoing legal dispute involving Blake Lively and Justin Baldoni.
Yeah, we've really tried to unpack it based just on that reporting. We covered the initial accusation of sexual harassment and the denial.
Right.
The significant $400 million defamation countersuit that brought in other names like Ryan Reynolds and Leslie Sloan.
The massive escalation.
The detailed allegations regarding legal tactics like DARVO, as laid out in Lively's reported legal documents.
The framing of the strategy.
The surprising involvement of numerous prominent advocacy organizations submitting those legal briefs to the court.
The external voices.
And these specific back-and-forth maneuvers reportedly happening in the courtroom around claims and evidence, all based only on the information presented in that one article we focused on.
Absolutely. It's crucial to remember our entire understanding and discussion today came directly from that single source we examined. We haven't introduced outside info or opinions.
So perhaps a final thought to leave you with, based on the source's content. Given the complex interplay the source describes, you have these serious accusations, the incredibly high-value lawsuits, the detailed allegations about specific and potentially harmful legal tactics like DARVO, and then the involvement of all these groups concerned with protecting those who speak out. What does this case, as described in the source, really highlight about the multifaceted challenges involved when these kinds of disputes play out both publicly, in the media, and legally in the courts? That's a question the source leaves us to consider, suggesting this is a story with implications that perhaps reach well beyond the headlines.